dear colleagues at bar, dear students of law, ladies and gentlemen, how to measure criminal liability? Yes, this is the topic for my today's video. How to measure criminal liability? Yani once a person is proved guilty through evidence beyond any shadow of doubt in a criminal offense, तो उसको जो सज़ा या पनिशमेंट देनी है वो कितनी देनी है, उसका तयन किस तरह से होगा। यानी लॉ ने अगर प्रोवाइड किया हुआ है कि अप टू 3 इयर्स, तो उन अप टू 3 इयर्स से मुराद में से आपने 1 महीना देनी है, 1 साल देनी है, 3 साल तक देनी है। व्हाट आर द फैक्टर्स विच आर टू बी टेकन इनटू कंसिडरेशन? दिस इज द इंट्रोडक्शन ऑफ माय टुडेज टॉपिक. First of all, what is liability? According to Professor Soman, liability or responsibility is the bond of necessity which exists between wrongdoer and remedy of a wrong. According to Mark Bai, the word liability is used to describe the condition of a person who has a duty to perform. So, meaning thereby, liability is the condition or the state of the person who has acted, forborne or omitted contrary to law. It may also be described as the state of a person who has violated a right or acted contrary to a duty. Now, liability is of two kinds basically, civil liability and criminal liability. So, criminal liability what are the factors which are to be taken into consideration? As regard to measure of liability, criminal liability is measured and 4 elements are to be taken by the courts of law while determining the quantum of punishment. Number 1, motive, yani muharrak. Number 2, intention, niyat, character of the offender and magnitude of the offense. Now, what is motive? Motive is which moves a man to do some crime. Motive is always an internal act of the mind. Motive होता हर केस में है, लेकिन सीनियर कोर्ट्स, सुप्रीम कोर्ट, हाई कोर्ट्स की कंसिस्टेंट जजमेंट्स हैं कि इट इज नॉट नेसेसरी फॉर द प्रोसिक्यूशन टू प्रूव द मोटिव in each and every criminal case, because motive is an internal act and sometimes prosecution cannot have the evidence to prove the motive. If the crime is being proved by direct evidence beyond any shadow of doubt, then there is no need to prove the motive. But at the same time, the Supreme Court in number of cases has held that if the prosecution has introduced the motive in FIR, then it is mandatory to prove the motive. Otherwise, it is not necessary if the act is being proved beyond shadow of doubt. So, first element which is to be taken while measuring the criminal liability or penal liability is the motive, muharram. And the second is intention, niyat. Now, what is the intentional act and what is the unintentional act? If the consequences of some act are desired or foreseen, the act is intentional. Let me repeat. If the consequences, nataij, of some act are desired or foreseen, it is intentional act. If the consequences of some act are neither desired nor foreseen, it is unintentional. So, first element which is to be taken in consideration while measuring the criminal liability, penal liability is the motive, second is the intention. The third element is previous character of the offender, whether he has committed the offense for the first time or he is the habitual offender. Third factor is also very, very important for the judges, honorable judges and the magistrates while determining. This fact is to be also taken into consideration. And magnitude of the offense. ये offense कितना बड़ा है, magnitude of the offense. So, while passing the judgment and giving punishment, jurists all over the world, they are of the opinion that these are the four elements, namely, once again, motive, intention, character of the offender and magnitude of the offense, which are to be taken into consideration. And with this, I say goodbye.